Equitable division is the name we use for our structure for how assets and property are divided in Connecticut. So, a couple things about equitable distribution. One, it's assets and debts. So, we're not just dividing the things that have value. We're dividing the things that have negative value. So, for example, we're dividing the equity in your house, and we're also figuring out how to pay the mortgage note that you owe in the bank, right? Both components are encompassed in our concept of equitable division. It's one thing you want to know. Something else to know about equitable division that really is confusing is that equitable does not mean equal in Connecticut. We are not a 50-50 property division state. We look at things more holistically than that. So we take a look at how the whole financial pie comes together, assets and debts. And then the court looks at factors to try and decide how to divide things. So you could have a scenario where things are divided 60-40 overall, but one person keeps 100% of the 401k and another person keeps 100% of the house, for example. So it's not just how we divide the whole thing, it's how we divide the component parts of each thing. It might make sense for one spouse to keep the family business and the other spouse to keep the family house. That doesn't mean that overall the division would be 100-100, right? The overall division might be 55-45 or something like that. The factors that courts look at when they're trying to decide how to divide things, you know some of them. One of them is the length of the marriage, right? How long have these folks been married? So, for example, in a longer marriage, we're going to expect things to gravitate more towards 50-50. For a shorter marriage, we're going to expect people to keep more of their own assets. Now that's true, but I have to pop an asterisk on that as well, because there are other factors that the courts consider beyond just the length of the marriage. The health of the parties, the income potential of the parties, the age of the parties, the education of the parties. You can see how a case where it's a relatively short marriage, you might have something approaching a more robust equal division of the assets because one person isn't able to work outside the home, for example, because of a disability or a health issue. So there are all of these factors. My best advice on how to figure out how things might lay out in your case is to talk to someone that does this all day, every day, who's helped lots of clients through the divorce process in Connecticut, so they can give you a sense of how a judge might view your particular circumstances. Another thing I like to talk about with property division that throws a lot of people, I was actually just reading an email from a client this morning where this issue was one of the topics in it. And I think that that's the concept of marital property versus separate property, which is a big concept in a lot of states. And I think that although the internet is great, one of the ways we fall down on the internet is on things that are highly state specific, and divorce and family law are one of them. You don't really know how things work in your state as comparison to the blog post or the news article that you happen to find on the internet. So how things get divided, for example, in California, there might be a concept of separate property versus marital property in California, and then the state's only dividing in divorce court what we call marital property. But in Connecticut, we don't have that. We're an all property state. So what that means is that all property, regardless of how it's titled, who owns it, and regardless of when it came in when that person came into owning it, before the marriage, during the breakup, all of that property can be considered. The court has the authority in Connecticut to consider all of that property when it's making its determination about how to divide things. What's that mean? Well, it means that your 401k from before you got married, the court's going to consider that and how to divide it. Doesn't mean they're going to divide it 50-50. It doesn't mean that they're going to decide that it should be divided at all. It just means that they're going to consider whether or not to divide it. This is why it's so important to meet early with experienced divorce counsel. Meeting early with us allows us to maximize our structure, to design the best possible strategy to set you up for the financial future that you want. And it allows us to do another thing. It allows us to be really candid and give you news that you do not want to hear. The thing that all of our lawyers commit to is telling clients accurate information, especially when they don't want to hear it. You can't make the right decisions for yourself and your family if you don't have accurate information. We do this day in, day out, and we know how different judges tend to look at different circumstances. And we're in a really good position to give you at least a sense of the scope of where you're operating. The thing that's important to know about Connecticut's equitable distribution view on how we divide property is that all properties the court can look at all property regardless of who owns it and when they got it. Doesn't mean they're going to divide it equally. Doesn't mean that they're going to divide it all, but it has the authority to look at it. The court also has the authority to divide it equitably. Doesn't mean 50-50. It means fairly in light of the circumstances of that particular couple. The other thing I like to mention when I'm talking about property division is I like to make sure that I talk about prenups, because prenups in some ways create an exception to how Connecticut divides property. So we know that we do equitable distribution in Connecticut, and we know that what that means isn't equally. It means that we divide things equitably or fairly. Might be 50-50, might be 60-40, depends on the unique circumstances of that couple. So if you have a prenuptial agreement and it's valid, it follows all the rules for prenuptial agreements in Connecticut, and it's not what we call unconscionable. In other words, that enforcing the prenuptial agreement wouldn't be unconscionable. It wouldn't result in this in an outcome that offends the consciousness of the court. Assuming that that's not what's going on, you can pre-decide how assets will get divided should you divorce in advance. So we do equitable division in Connecticut, but if you have a valid prenup that isn't unconscionable, the court will follow that agreement when dividing assets. So the next question that people usually ask when we're talking about how courts divide property is how they get valued. And that's really dependent on what type of asset it is and what's going on in the case. I'll tell you a little bit more about the first. We value assets differently based upon what they are. So for example, let's take a bank account or 401k. We pick a date and we know we use the value as of a date, right? That's how we value things. Those seem fairly straightforward. I have some war stories about when that isn't fairly straightforward, when there's like a stock market crash or things like that happens during the period. When a bubble bursts, things can get a little hot, even on cash assets or equities. So there are times where that's not straightforward, but basically you get the idea. The amount that's on the balance on the statement that you get, that's how we value those things. How we divide houses is a little different, of course, and that depends on what the couple's goals are for their future with respect to the house. So some couples sell the house and they'll decide in advance how to divide the proceeds of that house. So if the house sells for $1 million, then the house sold for $1 million. We pay the fees and the taxes and the realtor and all of that, and then they decide how to divide the proceeds. You know how it'll be divided, but you don't know the value until it sells. No problem. Very common. In other cases, though, one of the spouses is staying in the house. And so we have to decide how to divide that asset as to the other spouse, which means we need to value it. So say we're deciding one spouse is going to keep the house and the other spouse is going to keep the business. We might not know if those things are equal. We might not know if the house is worth $5 million and the business is worth $10 million. We need to value both of those things. For the house, the most common way to find the value is via an appraisal, a professional person who appraises houses, pulls comps, and comes up with a valuation. That is not a realtor, by the way. That's a professional appraiser. That's the gold standard for how we value a house if we're not selling it. For things like a business, we have a business valuation done typically. And that can be a little bit of an expensive process, but in a lot of cases, unless you have a publicly traded business that it's easy to put a value on because we know what the stocks are trading for, it does take a deep dive into a business to get an actual value for it. So valuing assets can be a complex part of the divorce process, but with experienced divorce counsel, there are gold standard ways of how to determine a value and how to advocate for the value that is the one that you think is the most accurate. So in higher net worth divorces, where you have people who either have high incomes or significant assets, finances tend to be more complex, right? We might have multiple properties. We might have properties owned in different manners. We may have generation skipping trusts. We may have trusts for the children. We may have other sorts of ways that businesses are titled or held apart from a straightforward ownership structure. So all of these things are something that it's important to work with a legal team where they're really experienced with the nuances of high asset divorces, so they can give you the most straightforward path to not only valuing those assets, but also to addressing how they should be handled in the divorce itself. Another thing that it can be difficult to figure out how to not only value but also divide are things like stock options. So a lot of our clients are executives at companies where part of their compensation package involves these benefits that are contingent on their continued work, or they may mature in the future. And those are things that can be hard to value. And we bring in experts who do this valuation process day in, day out to give us a sense of what we think the value of those assets are as of now. But one of the things that can be complicated is these types of benefits are tangible in the sense that they have been earned, or the prospect of them has been earned, but they aren't accessible yet. Something else needs to happen before anyone can get access to them. Time has to pass. Employment needs to continue. Goals need to be hit in the business. And so there's a lot of nuance to how to negotiate, or if you wind up not reaching a resolution, how to advocate for how these things should be handled in front of a judge. These are complicated assets that are somewhere in between existing and then the hope for the future. Another kind of asset that can be complicated is a prospective inheritance, something that is likely to be received, but isn't definitely going to be received. And one of the things that your lawyer has to be experienced in is the difference between money that might come to you via a trust when someone passes away, or money that might come to you via a will or as a beneficiary when someone passes away. These can be complicated situations, and you just want to make sure that you work with a team that is experienced in the nuances of all of the financial complexities of inheritances and other financial assets that are complicated, in addition to all the other things that need to happen in a divorce, like how parenting will work. This is one of the areas where you really need to make sure that you have the right professionals onboarded. You need an experienced divorce attorney who's used to complex financials. You need the experts that lawyer recommends that you retain to make sure we get through this in the best, most straightforward, most accurate, beneficial way we possibly can. There is a lot of money to lose if we don't get this right. And it's also one of the things in a divorce where it's really hard to fix it after the fact. Oftentimes we can not fix a bad decision if you're already divorced. So please find an experienced and sophisticated lawyer on the financials to work with as soon as possible as you're starting to consider divorce, even, so that we can structure things in a way that will protect your future.